This is something, as those of you who may have met before, something I feel very passionate about is I think that the agencies have traditionally undervalued their own offerings. And as a result of procurement and clients putting more and more responsibility on the agencies are failing to really recognize their own value and being compensated in a way that recognizes their value. So why legal? Well, particularly now, there are so many changes in the industry with digital, social media, loss of control. The client, everybody's a publisher. The client can take your materials now and use it elsewhere. You have user-generated content coming in. You have consumers who are also doing, whether through promotions and contests, content is coming from everybody. And yet the clients, in addition to making more demands of your cutting your fees, the clients, whether you realize it or not, and I'm sure most of you are quite sophisticated that you do realize it, the clients are putting more and more liability on the agencies. And we're also going to talk a bit about the rise of the patent troll. And so you're thinking, well, why legal? We're having a compensation seminar. Why are we talking about legal? Well, the reason is it does come down to the compensation. Because you can spend so much time negotiating this fee, and you can come to what you believe is fair compensation, whether performance-based, fee-based, whatever. But if you get hit, and I'm sure most of you in this room, if not all of you, have from time to time been hit. But if you get hit with some of these liabilities, there goes your compensation. And in point of fact, a number of the things I'm going to talk to you about today are not covered by insurance, which is the scariest part. So it is important for you to understand and not divorce these kind of conversations, which is, yeah, the lawyers will talk to you about it. Yes, we just have to get this done. Yes, we want to get the compensation. You know what, we tried, but we're not going to get it. You have to understand the impact of what you're agreeing to. So the first thing is ownership. Particularly in the digital world, your intellectual property is the framework for leveraging and getting additional compensation, and also making sure that you're not losing money on your proposition. Particularly in digital, where we have software and tools. In the bricks and mortar world, where many of us grew up, where you had stage direction and things, nobody could own that. So if you did a commercial for a client and you used a certain stage direction, nobody would own that. The problem in the digital world is we give copyright ownership to software and tools that, if they were in the bricks and mortar world, wouldn't be ownable. So when you're giving all rights to your clients, and you're giving, because your clients feel that if we paid for time, we want all the results and proceeds of that time. That's fine when you're developing a car commercial. It has no applicability beyond the particular commercial for the particular client. But when you're creating software, a means of uploading a picture, a means of navigating between pages, 3D technology, that software and those tools of yours, basically your hammers and saws in the digital world, have applicability beyond each client, an individual client. And if you give ownership of each of those things to each client, first of all, you'll eventually be out of business. Or you're going to ignore it and do it anyway and hope that you don't get caught. But at the end of the day, if you take it to its logical extreme, you're giving away things that really do have value. And you have to be very careful in these negotiations as you're looking at intellectual property and the traditional work-for-hire structure where you say to the client, everything you're paying us, everything we produce belongs to you. Now, we'd love a world in which, in fact, you're licensing things. We keep our IP and we license it to you. That's down in the future. One day, I hope we get there. It's a long way off. But you can't just assume it's an all-or-nothing proposition. There are certain things that agencies have to retain in order to stay in business, in order to get the value of what you're producing. One of those things is software and tools. The other thing is before you even get into an agency relationship, when clients on a pitch say to you, you have to assign all intellectual property rights just to be in this pitch. We're not paying you, but you have to give us all of your thinking, and we own it. I mean, I think we've at the 4As have had many discussions about this, but if you talk about value, how can you later say to the client, this is the value of what I'm creating, and get beyond a labor-based model if you're giving it away in the pitch? So even if you're willing to entertain this notion, which I think to some extent, as an industry, we have to do, of giving up, at least for now, IP, there's still carve-outs that have to be had. The pitch, software and tools, out of scope. If you're busy, and we've had a lot of conversations today and wonderful conversations about crafting a scope, well, what happens if I pitch something that's out of scope? Can the client just take that because I pitched it and develop it with another agency? What's the value of that IP that I've created? If I go in and say, this is a great idea for something that is, we've spent so much time on this scope, can they take it? These are things that you have to think about in order to make sure that you're getting the value of the compensation that you have spent so much time negotiating. And this is why these discussions can't be divorced from one another. The other area, and again, I'm giving this very short shrift because I do only have a few minutes, and I know each of these could be very major topics. But the other area where we're very concerned, which affects compensation, is the indemnification and liability. It is amazing to me that at the same time clients are cutting your compensation and coming in with procurement and hammering it down, they are increasing your liability. They are asking you to treat advertising like a widget and basically say that you are making a warranty that it's going to work a certain way. And advertising doesn't work that way. In the first instance, there is a division of responsibility. There are certain things in advertising for which the client should be responsible, and there are certain things for which the agency should be responsible. If there's a product claim in that advertising, the client needs to take responsibility. And if you've been following some of the types of lawsuits that have been out there, where Reebok got hit with $25 million for false advertising on their exerciser shoes, where Dannon was $64 million, I think, in total for the activity of yogurt and the whether or not it helps your digestion. We cannot, under any circumstances, take responsibility for those things. We rely on our clients, and we have to make sure that they're going to take responsibility. Now, we can say, of course they're going to. Why would they trust the agency to litigate something like that? That may be true in some instances. But there have been times where clients do try to push back on an agency and say, well, you came up with the claim, therefore you should be responsible. And it should never be the case. Also, again, as I started out with this in this session, saying there's all these uses of materials. In the old days, when it was a commission structure, the agency held onto the elements. You had the master, you had the dubs, and you could make sure that it was under control. Now everything's digital. It's posted on YouTube. It's put here. Consumers use it. So we have to be very careful that if there's some unanticipated uses of materials, that we're not responsible for those. Preliminary materials. How many times have you gone into pitches and shown preliminary materials? The clients take them and use them at a press conference or at a trade show. We can't take responsibility for that. If they misuse the materials, the consumer elements, and we can go on through this. But the point of this is that with each of those things, if you just assume that it's no problem and the agency takes on that responsibility, it can impact how much compensation you ultimately are able to derive from this carefully negotiated structure. Now, the agency is responsible for IP claims. We all know that. Copyright, trademark, we're supposed to get our clearances. That's fine. But we do have to consider, in the old days under the commission structure where we really did control all of the IP and all of the use of the materials, that was fine. But now, we have a loss of control. We have to go through this agreement and make sure, even though your agreements, particularly those agreements that have been in place for years and years, that you've thought about these things. If it's not within our control, we can't take responsibility. We only indemnify for final materials, not for preliminary materials. And then only if you use those materials consistent with agreements with third parties. If we tell you 1 year US only and you use it for 3 years, we don't take responsibility. Really important, the territory. With more and more global relationships, when the clients, it's a very big difference between getting rights to use a piece of music worldwide and clearing something worldwide, because there's a cost associated with that clearance. The laws in different countries are different. There are things that are freely usable in the United States because they're public domain, but they're protected by intellectual property laws in other countries. So if you say, yeah, sure, we'll get all rights everywhere in the world, and you don't carve this out, one of two things are going to happen. You're going uninsured in various countries in the world, or you're now spending legal costs that are not being covered in that compensation model to have things cleared in various countries throughout the world. So These kind of conversations you need to have up front with the client and make it part of that whole compensation structure because it does have an impact. And finally, and perhaps most importantly, which I'm sure everybody has been talking about in the industry, is patent trolls. What is the agency's obligation for patent claims? This is such a huge issue right now because patent claims, and patent trolls, for those of you who don't know, are people who are in the business. They don't necessarily even operate a company. They buy up patents, and their whole business model is to find people to enforce patents against. The main business is against the major software companies, and they sue in the Eastern District of Texas, where courts are very friendly. But they are coming after the agencies. And I'm sure if you don't know about it, many of you in the room, others have been hit by it. I'm sure you've all at least heard something about it. With each of these claims, the problem with patents is, number one, you do not have insurance. Number two, you cannot effectively search for patents because of differences in nomenclature when you register for patents, because of the cost of searching, because of the number of patents. Unlike a software program, the number of patents that are implicated by a single website can be, perhaps 100. So there's nothing you can do about it. And then the patent trolls come and they take patent positions on absurd things, ideas, because of these what's called business method patents. They make claims against very broad-based things. The double click. I could go into many examples of these kind of absurd patents that are out there. And what they do is they come to you and they say, either pay us or we'll sue you. And to defend a patent lawsuit costs $2 to $3 million, but we'll be happy to settle with you for a couple of $100,000. Now, clients are looking to you. Now, there's nothing you can do about it. There's no way that you will know about it. You don't have insurance for it. It's a cost of being, and if you're on the web or in mobile or anywhere in digital, this is a reality of doing business. And yet, the clients tell you that you need to take on this liability, and many times agencies are taking it on. And if you get hit repeatedly by these patent claims, you can talk about hundreds of thousands, if not, if you got multiple patent claims, it could be $1 million. And there goes all of this carefully negotiated compensation. So what do? It is all about the agreement. And one of the most important things, and I think is coming out of today, and I'm going to say the exact same thing, you have much more power than you realize. It's about fairness. It's about believing. When we talk about all the things we've talked about today, I feel like, to me, there's such a passion and a question of what's right and what's wrong and fairness in this whole thing. And, and certainly there are certain things that the agencies have to take responsibility for. But when you start talking about this, first of all, you need to understand not only the compensation landscape, but also the landscape of these kind of intellectual property and these kind of liabilities. Because you need to be able to have a discussion with your client. You need to believe what I believe, which is that fairness should dictate, and you cannot just take responsibility blindly for all these claims. You need to educate the client. You need to recognize that just like when they tell you that you have to cut your compensation, if they come in and tell you you have to take responsibility for everything, you have to recognize what the impact of that is, and either you have to think about it and say, would this client be worth it to me if I had to pay out of pocket $200,000, $300,000, $400,000? Even if there's a 30% chance, 20% chance. Am I getting compensated? Because when you're taking on particularly patent liability, you are now operating as an insurance company. Insurance companies have deductibles, they have caps, and they get paid premiums. Particularly if you're getting paid on a labor-based model, where is all this being covered by? Or is this simply a game of taking our chances, holding our breath, and hoping it doesn't happen? And, I think that when you're discussing this, procurement may say this is just part of it, we have to take responsibility. Get the attorneys in. And if they say that you have to take responsibility for this, you have to understand what that means to your bottom line. And my personal opinion is you have to be prepared to negotiate and push back, no different than on compensation, and have the confidence to do that. And if there is, and if you do agree to it, you have to get paid something extra for it, or you have to have some reason to do it. Because honestly, with these liabilities, if you give up ownership, if you take on liability, at the end of the day, you are giving your client much more than you contemplated when you came up with your compensation models. You could be losing money on a client much more than you thought. Forget about your profit margin. You could be now cutting into costs. So these are really important conversations to have. This is a very abbreviated version of this, but what Tom asked me to do and what I would like to do is to make sure at least that you understand this and at least recognize this, because sometimes the contract is kind of pushed to the side. We've got our compensation, we're happy, we're done, and yet we're not focused on some of the possibilities that could and frankly are happening much more often. And I can't tell you, it breaks my heart when I get these phone calls from, somebody will say, an agency will say, well, we got hit and we're covering it. And, how could they do that to us? And, there's nothing you can do. So that's it. How was that? Time-wise? 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 Did I do my time?